Can Parliament amend everything in the Constitution? What if one day you wake up and found that your fundamental right is no more in existence? It had already happened in past, but doctrine of basic structure has emerged as a protection shield of the Constitution. We are going to talk about everything related to this doctrine from 1973 to till now. We are going to talk about five important things: historical background with case laws, Keshav Nanda Bharti judgment, doctrine of basic structure, major cases after Keshav Nanda Bharti case, and importance of doctrine for judiciary exam. So let us begin. In 1951, there was a case, Sankri Prasad Singh Deo versus Union of India, in which constitutional first amendment as well as Article 31A and 31B was challenged. Now, why this issue come up in court? Because constitutional first amendment was made to Article 19 clause 2nd to include public order as restriction on freedom of speech and expression. It also led to amendment in Article 15 clause 3 and 15 clause 4, permitting state to make special provision for ST and SC. Whereas Article 31A relates to acquisition of estate, even if it violate Article 14, Article 19 and 31. And Article 31B relates to the introduction of ninth schedule to the Constitution, with aim to protect laws put in ninth schedule from judicial review. Now, 5 judges bench was made to decide this case, and it was decided that Parliament can amend fundamental rights. Thereafter, in 1965, in Sajjan Singh versus State of Rajasthan, there was 5 judges bench to decide the validity of 17th Amendment made to the Constitution. By this amendment, Parliament put some laws related to estate in 9th schedule to protect them from judicial review. With a ratio of 3:2, the same view was upheld in Supreme Court, as in Sankri Prasad case. That means, yes, Parliament has power to amend the Constitution, even if it affects the fundamental right. But things started to change in 1967, when in Golaknath and others versus State of Punjab, there was an issue in Supreme Court, and the issue was whether the Parliament could amend the fundamental right provided in Part 3 or not. The core issue was whether the constitutional amendment made in Article 368 could be considered as law under Article 13. It means if the amendment as per Article 368 is considered as a law, then Article 13 says that state should not make such laws which violates Part 3rd. Now 11 judges bench was constituted and the ratio was 6:5. Supreme Court decided case by declaring that Parliament cannot affect Part 3rd. It means that Parliament could not amend fundamental right, and Supreme Court limited the scope of Article 368. Supreme Court applied the doctrine of prospective overruling also, where the court overturns the previous ruling but applies the new rule only to future cases and not retrospectively. That means in Golaknath case, Supreme Court overruled the previous judgments of Sankri Prasad and Sajjan Singh case, but the judgment was applied prospectively, not retrospectively. Another issue came from Kerala, where Kerala land reform laws that restrict the property ownership of Keshav Nanda Bharti. The issue was whether Parliament has power to amend the Constitution under 368 was absolute or whether it is limited. Now 13 judges bench of Supreme Court by majority as to 7:6 ratio established the doctrine of basic structure and upheld that Parliament can amend the Constitution, but it cannot alter or destroy its fundamental or essential feature or the basic structure. So what is basic structure? There are certain fundamental features in the Constitution. They are inviolable, means cannot violated or altered by Parliament through amendment. For example, if Constitution is a building, then Parliament can change the window or door, but Parliament cannot change the foundation of building, because change in foundation of a building might lead to the destruction of the whole building. Means if basic structure of Constitution is destroyed, then whole Constitution will get destroyed. Now, what is the basic structure? Or what are the basic features in doctrine of basic structure? It is the supremacy of the Constitution, rule of law, separation of power, judicial review, federalism, free and fair election, secularism, independent judiciary. And remember that it is just an exhaustive list. The scope can be extended by the court time to time. Now, as we know that what is the doctrine of basic structure, let us discuss what are the case laws in which this doctrine was applied after Keshav Nanda Bharti case. In 1975, Supreme Court struck down clause 4 of Article 329A, which sought to prevent the election of PM from judicial review. Now, Supreme Court considered it as a violation of doctrine of basic structure and emphasized the importance of free and fair election. In 1980, another case was Minerva Mill case, in which 42nd Amendment was challenged, as Parliament introduced Article 368 Clause 4 and Clause 5 to expand the power of amendment. Even fundamental rights. Supreme Court stated that Parliament's amending power is not absolute and that certain feature cannot be altered. Supreme Court in this case declared that Article 368, Clause 4 and Clause 5 are unconstitutional. Another case was NJAC judgment, in which Supreme Court struck down National Judicial Appointment Commission Act and 99 constitutional amendment was declared as unconstitutional, as it violates the doctrine of basic structure. Why? Because Parliament introduced Article 124A, which led to the involvement of politicians in the appointment of judges of Supreme Court. Now, the bonus step is that this topic is very important for your judiciary exam and even for preliminary as well as main, both. So now, if you want the detailed notes for free, then comment doctrine of basic structure, check the WhatsApp link. If you are interested in joining the live batch for judicial service, you can fill out the enrollment form. All the important links are given in the description box. With this, I would like to end. We'll meet in another video. Till then, goodbye.